This question looks at the liability of shareholders in the case where a company is being liquidated. So the scenario here, Ho subscribed for some partly paid up shares in IO Limited. So if they are partly paid up, what that means is Ho has contracted for the shares, so the contract has gone through, but the full payment for the shares has not yet gone through. So Ho owns the shares, still owes some money. Now the company has not been successful, and Ho has been told that when Lo is liquidated, he will have to pay the amount remaining unpaid on his shares. He's not sure who the payment should be made to. So we've got here a limited liability company. Who is the shareholder liable to? Now, we need to be very clear about whose relationships are with whom. Now, with a limited company, the contractual relationship is between the company and its creditors. So we talk about the veil of incorporation that protects the shareholder. So in the event of the company being wound up, the creditors cannot go directly to the shareholders in order to get the debts paid. That route is blocked off to them, with some exceptions, but generally speaking, that's what limited liability is. It limits the liability of the shareholders. Now, this is a slightly different situation because we have here Ho, who is the shareholder. Now, Ho owes money to the company. And he owes money for the shares that he has been handed, that have been handed over to him, that he now owns, that he hasn't fully paid for. So when the company is liquidated, that transaction needs to take place. Ho needs to hand over the money that he owes to the company. And then, of course, what the company can then do, or in this case, the liquidator of the company, can then distribute that money to creditors. Therefore, shareholders are liable to the company for any unpaid capital. That's who their contract is with. The fact that that money might then be transferred to somebody else is not the point. The contract is with the company, so that is whom they are liable to.